Well, thanks so much for the kind invitation. As always, it's a pleasure to be here at one of these spring conferences. The topic today is copyright and freedom of expression. So obviously the idea is that we go into more detail after the general framework that has been discussed this morning. So what I have prepared is first a general risk assessment. What is the general relationship between copyright and freedom of expression, and then we look at what is called in literature internal balancing. So you use the tools inside copyright law to achieve a proper balance on the one hand, and external balancing, really invoking the fundamental rights guarantees as an extra argument to arrive at a certain solution. And then we will discuss finally what the human rights approach really has to offer in copyright law. So here's the risk assessment, and there I would join our chairman in asking, well, what's the problem at all? I mean, copyright traditionally is seen as an engine of free expression, and I think this is something we should not forget. In fact, in the past, without copyright, you very often had a situation where creations were not fully independent. You were dependent on somebody sponsoring your work, patronage, and so on. So copyright in this sense is a perfect tool for giving authors an independent source of income and stimulating more independent creations. In cases such as Harper Row, Nation Enterprises, this can lead to a situation where the court says, well, the right of first publication is an essential aspect of this copyright serving as an engine of free expression. So copyright as such has lots to offer in terms of more freedom of speech. But of course, there are problems. And one of these problems is that once you protect the original work, then follow-on innovation also becomes more difficult. So the derivative work is dependent on granting permission from the rights owner from the first work. And there, of course, we can say the grant of protection is not only an incentive for creation, but is also something that might frustrate follow-on innovation. So this innovation cycle might become more difficult because there is copyright protection. There are books written about this. Just one example, Copyright's Paradox. Neil Nathaniel has written a whole book about this internal tension in the copyright system. And then, of course, we have the censorship cases very often coming up with journalists, a decision that has not featured prominently yet. But when we look at it, the Ashby Donald decision of the Court of Human Rights was just one of the cases where journalists thought they could publish their photographs of haute couture creations on their webpage. And in fact, this raised the question of copyright restricting the freedom of sharing this information. So there are tensions, there are cases where a decision has to be taken between copyright protection on the one hand and freedom of protection on the other hand. And then, first of all, the question is, can we solve this internally? Does copyright law have sufficient tools available in order to achieve at a reasonable solution? And there I would say the EU acquis, as we know it, is not the best framework for doing the internal balancing because we have broad exclusive rights, so this is well developed. But on the other side of the equation, the exceptions and limitations are listed in an exhaustive manner. So it's a closed list, and on top of that, the three-step test. And we know what the Court of Justice has said about it. In Infopac, first of all, the general rule is protection. The exceptions and limitations are subversive exceptions to that rule, so they must be interpreted strictly. And this is even the more important because we have the three-step test in Article 5.5 of the Information Society Directive, and this also points very clearly towards a strict application of the exceptions and limitations. So from a fundamental rights perspective, this is problematic because if this is the scope of fundamental freedoms, then the first limiting tool is the list of exceptions in the EU acquis, and if we don't find something in the list, then the use is not permissible. And then even if you find something in the list, right of quotation, parody or something, then still the three-step test might put an end to the use permission. As a counterbalance, and I can be short on that because Jonathan Griffith has already discussed this in much detail, the course has introduced this meta-doctrine of fair balance. In Premier League, it said a fair balance between the rights and interests of right holders on the one hand and of users of protected works on the other. So the important point here is the users also do have rights and interests. It's not only interests, it's also rights. So they meet at equal level, at eye level, we could say. Then in Eva Maria Peiner, the same point with regard to the right of quotation with a focus on freedom of expression. And then in the Deckman decision, the court was very clear in saying, well, what we mean when we refer to the rights of users, it's really a right, namely the right to freedom of expression of the user of a protected work. So this is the general framework, a hybrid framework, we could say. On the one hand, quite a restrictive approach because of the dogma of strict interpretation of exceptions and the three-step test. On the other hand, kind of an opening clause, which the court introduced itself by saying we must ensure a fair balance. The main point for my talk here is not so much these internal tools. This is something we have already explored in the morning to quite some detail, but let's see what happens at the national level. And there, of course, the examples of case law where a court really says, I can't solve this within copyright law. I have to go ahead. I step outside the copyright system and I invoke the fundamental rights in some way or the other. These instances are very interesting. I start with two cases from Germany. One case, it's an older case, just to show that in Germany this is a development that started well before the Charter and so on became the role that it presently has in EU law. This Germania 3, Gespenster am toten Mann, difficult to translate, I won't try. This was a play written by Heiner Müller, and you could say it was kind of a collage technique. He had included substantive portions of earlier works of Bertolt Brecht in order to discuss Brecht's political positions. The copyright owners to Brecht's work saw this as an infringement of copyright. They said, the quotation goes too far. This is no longer a quotation. This is basically verbatim copying of the original work. But it was, on the other hand, quite clear that this was in the context of artistic discussion. Heiner Müller is a highly recognized, high-profile writer, so it was quite clear that Bertolt Brecht and Heiner Müller are both artists. Under the German system, a review of decisions of the courts in civil law matters has always been possible in the light of constitutional rights, because there is not only the Supreme Court, the German Federal Court of Justice, but if you are not satisfied with a ruling handed down by the German Federal Court of Justice, then with regard to constitutional rights, you can always bring an additional appeal to the German Federal Constitutional Court, which makes the German Federal Constitutional Court a kind of super appeal court in German cases. So in this case, Heiner Müller, well, it was his years, they brought the case to the Federal Constitutional Court, and the court said a proper balance, again, the balance that is now featuring prominently also in EU law, a proper balance is required between the different constitutional rights at stake. On the one hand, the interest of copyright holders in protection, which falls under the right to property, and on the other hand, the artistic freedom to enter into a dialogue and base creations on pre-existing works without running the risk of financial interferences or interferences with regard to contents. So as an artist, you should not be bound to choose particular solutions for an artistic problem. Instead, you should be free, regardless of whether the material you are using enjoys copyright protection or not. And then the court said the copyright limitations, in this case the right of quotation, must be construed in the light of freedom of artistic expression as guaranteed under the German Constitution, which is 5.3 of the German Basic Law. So the balancing of copyright and freedom of art is necessary, and then Doing this in terms of a proportionality test, the court said, at least when the possible economic harm flowing from a quotation cannot be perceived as significant, then the freedom of art has more weight than the copyright claim. And this was the situation in this case. So Heiner Müller's play, in the end, did not amount to infringement under a human rights analysis. The important point here is that I am presenting this as external balancing, but what the court finally does is explaining how the secondary copyright norms have to be applied in this case. So the court is not saying the quotation right is not applicable, so we base the exception directly on the freedom of art. Instead, the court said the freedom of art tells us that this is a permissible quotation. So whatever you do, you must interpret the right of quotation in copyright as permitting this particular type of use. A second case, and this is a more recent one, this is the famous Metall auf Metall saga. On the one hand, we have the composer of the piece Nur Mir, Sabrina Setlur. I don't know if Sabrina Setlur is a well-known artist here in the UK. In Germany, she was at the time, actually, at least I was confronted with some of her music. The composer of one of her masterpieces used a rhythm fragment, and that was taken from the Kraftwerk piece Metall auf Metall. So it was a taking of 2 seconds, and this was in a constant loop underlying this secondary work. Kraftwerk, I think, most of you will probably know, I mean, they are pioneers in electronic music, one of the most important bands in that area. And they, in this case, could invoke not only copyright, but also the neighboring rights as phonogram producers of Metall auf Metall. This is part of an album called Trans-Europa Express, and the phonogram was first published in 1977. So this is Trans-Europa Express. And Kraftwerk, this is illustration for teaching, what I'm doing here. After a lunch break, this is... Well, I thought, yeah. And this is Sabrina Setlur. So you see the difference. I didn't think this works that well, actually. So, okay, again. So this is Kraftwerk, this is Sabrina Setlur. And now we start with the decision of the German Supreme Court. In the first decision, the court said, well, the phonogram producer makes his investment with regard to each and every part of the sound recording. Providing the finances necessary organizational efforts to bring the sound recording about means that the investment has a direct relation with even the smallest parts of the recording, and therefore there is no part of the sound recording that remains unprotected, which means that Kraftwerk had a stronger position under this neighboring right than it had under copyright, because under copyright the question would have been, is 2 seconds a taking really substantive enough? Do these 2 seconds represent the originality of the entire work to such an extent that the 2 seconds already enjoy protection? This case was not relevant here because the court said the phonogram producer has a right with regard to whatever snippet taken from the work. And then the court said, well, this approach, protecting even smallest fragments, does not impede cultural follow-on innovation because the secondary author can make a recording himself by taking similar steps. An equivalent sound can be produced by the secondary producer himself. There is no need to take over the sound recording of another producer. That was the general approach. And then, as you may see here, the question is, of course, if we say equivalent sounds, what does equivalent sound mean? So how much effort is necessary, is acceptable for the secondary author? Well, the case went back to the lower courts and returned to the Supreme Court because it was not sufficiently clear in which instances a sound result would really be equivalent. So this led to a further decision, Metall auf Metall second, and there clarification of the applicable standard was sought, namely the Supreme Court said, what I meant to say was, the question is whether an average music producer is capable of making a recording himself, which is comparable from a musical point of view. And the court added, this is a relatively strict standard. It is irrelevant if the necessary effort can be deemed acceptable. In particular, a quite long production period for a snippet of 2 seconds does not mean that it is not acceptable. So even 2 days production time might be acceptable. There's an interesting background to this. Before the case came to the Supreme Court again, the lower courts had done some fact-finding, and Kraftwerk had presented an expert witness showing that using a hammer and hitting a wheelbarrow with a hammer would be one way of achieving a relatively equivalent sound result. So imagine the court setting. Yeah? So you had a lower court, and Kraftwerk would come in with a wheelbarrow, and they would smash the barrel. They would smash the barrel with a hammer, and they would say, "Okay, you see, this is quite comparable." So this is what you end up with in these cases. And this was not the end of the story, because the composer of the piece said, I can't believe this is just not true, because it basically places a very heavy burden on a whole genre of music. There are music genres like rap music, hip-hop, and so on that heavily depend on sound sampling as a starting point for this type of creativity. So the case was brought, as I explained earlier, as a super appeal to the German Federal Constitutional Court. And that court last year said very clearly, protection of smaller sound fragments in case of a possibility for the secondary producer to produce equivalent sound encroaches upon the freedom of art. So the Supreme Court has not taken sufficient account of the guarantee of freedom of art. And to arrive at this conclusion, the German Federal Constitutional Court also focused on the objective underlying the grant of the neighboring right in the first place, saying, well, this right was not granted in order to squeeze out licensing fees from every secondary user who uses 2 seconds of a sound snippet. Instead, the protection of the sound recordings is granted as a tool against phonogram piracy, and this is very different from the licensing business that has evolved around sound sampling. So the German Federal Constitutional Court was also satisfied that this ruling would not go to the heart of the neighboring rights, because the piracy, the weapon against piracy instrument would still be available. So the final conclusion then is similar to the earlier decision in Germania 3. The economic harm flowing from the taking of a small sound fragment was not deemed significant in this case, whereas the impediment of artistic freedom in the field of sound sampling was seen as significant also when considering the broader context. It's very interesting to see that the court here said, well, it is not sufficient that in copyright law you find just some solution to solve the case. It is also important to consider the potential deterrent freezing effects of legal uncertainty. So if you provide a rule of, you can only legitimately reuse a sound recording if there is no way of producing a comparable sound yourself, then the rule is so uncertain, then this will have a deterrent freezing effect on the further development of art, and this is unacceptable. There's quite some support for this. For some further reading, I find this a very interesting analysis, not of this case, but of the US case Bridgeport Redux, where David Morrison compares different types of sound sampling paradigms and says, well, one is the derivative work sampling, where you use just a small number of pre-existing resources, 3 or 5, in order to arrive at a new work. And there he says, okay, this is something that is perhaps not so much, that is not so difficult from a copyright perspective, because rights clearance of 3 or 5 pre-existing sources will be more or less an easy task. By contrast, collage sampling, where the sound sampling artist uses thousands of pre-existing sound snippets, this will die if copyright law is enforced too strictly, because you will never find a producer willing to clear these 1,000 snippets taken from pre-existing sources. So from the perspective of art theory, music theory in this point, there is quite a robust consideration underlying the ruling of the General Federal Constitutional Court that this should not be the question. Yeah? So the freedom of art prevails in this case. It is interesting to see that, again, the solution is an interpretation of the existing copyright norms. The German Federal Constitutional Court says, again, we do not directly invoke the freedom of art as a basis for the use. By contrast, the lower courts have to arrive at a solution by doing one of two things: either a more restrictive interpretation of the scope of the sound recording rights, that the taking of 2 seconds is immaterial in the first place, or a broader application of the rule of free adaptation or free use, which is a domestic doctrine in German copyright law. So freedom of expression, thus no independent direct basis for sound sampling, rather a tool for arriving at the right interpretation of the secondary law. This is something I would like to contrast with developments in the Netherlands, where you see a more direct reliance on constitutional rights. So the German strategy, you could say, is reading copyright norms through the lens of human rights, and in the Netherlands, a bit more pragmatic, you could say, the direct application of human rights. So if you don't like the solution that you find under copyright law, then you just make the switch and you invoke the human right. An older case in that respect was a journalist case. Karin Spink, a journalist, had criticized the Scientology Church, a case that ended up before the Court of Appeal of The Hague, for criticizing Scientology's general principles and policies. She used quotations from confidential parts of court declarations, which the Scientology Church had made in a case against Mr. Fishman. And as these were confidential documents, Scientology argued this amounted to copyright infringement because the right of quotation only covers quotations of sources that have been published lawfully before. So without a lawful earlier publication, you never have a legitimate quotation. The Court of Appeals accepted this and said the right of quotation is indeed inapplicable in this case because the source was not lawfully made available, but, the court said, then we apply directly the guarantee of freedom of expression, including freedom of the press, under Article 10 of the European Convention on Human Rights. Quotations contribute to a legitimate form of criticizing Scientology's questionable ideas and behavior. And the court said, against this background, use of the documents do not amount to copyright infringement. But again, my reading of the case is this is a direct invocation of Article 10 of the European Convention of Human Rights. A more recent case, the Anne Frank case, concerned the manuscripts, the original manuscripts of Anne Frank's diary. The case is between the Anne Frank Foundation in Switzerland, located in Basel, and the Anne Frank Foundation in the Netherlands, located in Amsterdam. So let's look at the Basel Foundation first. This is a foundation established by Otto Frank, the father of Anne Frank, established to support social and cultural activities in the spirit of Anne Frank. This foundation inherited copyright to Anne Frank's works as the only heir of Otto Frank. And on the other hand, we have the Anne Frank Foundation in Amsterdam. They take care of the Anne Frank House. They run and maintain the Anne Frank House, and they have the material copies because the manuscripts of the diaries have been given as a loan to the Anne Frank House from the Royal Dutch Academy of Science, who is the owner in a property sense of the manuscript. The background to the case is as follows. The Anne Frank Foundation in Amsterdam undertook in-depth manuscript analysis together with the Royal Academy of Science in the Netherlands, and this required scanning of the manuscripts and also transforming the manuscript in digital readable format, in XML-TEI format, whatever that is, but there were acts of reproduction involved here. The Dutch Anne Frank Foundation also had plans to make the digital text versions which they had created available on the internet, but during the case they declared that they would not do this without consent of the foundation in Basel. And so the remaining question before the court was, is the making of several copies for research purposes, digital copies that would be used by the researchers to do this manuscript analysis, is this something that amounts to copyright infringement? And here the court said, well, first of all, the copyright was not expired in this case, even though Anne Frank died 1945 in Bergen-Belsen. So if you add 70 years to that, the copyright would already have been expired, but because of posthumous publication and the specific rules in the Netherlands that still apply even after harmonization, the copyright still enjoyed protection. And then it was also clear that the reproduction amounted to infringement, and the court was also concluding that there was no copyright exception available in this case. It was not right of quotation because the manuscript had been copied in their entirety. It was not the library reading terminal exception because the researchers were not sitting at reading terminals in the library. It was not private copying because it was for professional research purposes, and it was not for preserving the manuscripts because they had been preserved already. It was really an additional copying, so none of those was applicable. And then again the question was, okay, is there an alternative basis in order to make this research use possible? And here, the District Court of Amsterdam invoked the fundamental freedom of science as an external limitation of copyright, and the court did this while also applying a proportionality test, pointing out first that the public interest in this research is self-evident. Acceptance of the copyright claim would lead to a serious impediment of research activities concerning the works of Anne Frank, and the Basel Foundation had not given a sufficient justification for their copyright claim. So note the difference here. Yeah? When you look at copyright from this human rights perspective, the copyright owner has to give a sufficiently strong and sound justification for bringing the copyright claim in the first place. So you are on the defense, you have to explain why you rely on copyright altogether, which is quite extraordinary when we look at copyright as a subjective right against everybody. So the fact that somebody copies basically is enough to conclude that there is infringement. So this was the second decision, and it was influenced by the GS Media Sonoma decision of the Dutch Supreme Court. You may wonder why a first instance court is so courageous to do all this. It was because in the decision where the Dutch Supreme Court asked the prejudicial questions that led to the hyperlinking case at the EU level, the court made a very important general observation by saying that the judge, in case of a defense argument to that effect, must examine whether, in the concrete case, the enforcement of an intellectual property right cannot succeed because of another fundamental right. So it's the Dutch Supreme Court who said, well, whatever you do in copyright cases, you have to look at the different fundamental rights, and this has also been implemented in practice. So I'm a practicing lawyer myself, at least one day a week. So when we argue cases now before Dutch courts, we present all the copyright arguments, and then on top of that, we add an analysis of the case in the light of fundamental rights, because this is what the Dutch Supreme Court says, and so we can expect courts to follow this line of argument. So answering to the suggestion that has already been made by our chairman, this has been fully implemented in the Dutch legal system, you could say. Still, the question is, where are the limits of this human rights approach? And I would say the limit quite clearly is that you get additional flexibility only case by case. In the specific circumstances of the cases, the courts are willing to go beyond, but you do not get a creation of new exceptions case by case. So I wouldn't expect this human rights analysis, for example, to lead to the introduction of a further exception for user-generated content or a further general exception for sound sampling or something like this. It is a solution for the individual specific case. So with regard to the fair use question and the discussion about flexibility in the EU copyright system, I'm still not sure whether this human rights approach is a full alternative to the introduction of a more open system. With regard to a more open system, I think another approach taken by the Court of Justice is quite interesting. In the Technical University Darmstadt case, the court took the reading terminals exception as a starting point and said, this exception does not function properly without a digitization. So the digitization must be read into this reading terminal exception, and then to allow the users of the reading terminal to also make copies, the court also said the private copying exception can also be combined. So by combining several more specific exceptions, the court arrived at a much broader use privilege. So I think if we apply human rights methodology to combine more individual exceptions, we might in the end further strengthen this approach. So I hope this was a bit of extra food for thought after the lunch. Thank you so much.